Well, it's 7 o'clock, so I'll try to get us started. Thank you, everybody, for being here. I understand we're competing with graduation. So, I guess that's on video too. We'll watch that after the fact. The parade went through town as I was coming in, so.
Most of us in the room already graduated.
Well, I think all of you already are aware, I'm Carolyn Mullen. I'm the director of the Senior Center. And you're also probably aware that if you need a restroom, they're down the hall and to the right. But thanks again for being interested in this topic. I think it's a really meaningful opportunity for any of us to think about what impact we leave in the world. And I was really fortunate that we ended up with a really wonderful set of panelists here today. These are people I turn to a lot. I often need the advice of a lawyer or a financial expert or a foundation expert, and each of them overlaps so much. So I think you'll find in tonight's presentation, while Laura's going to lead the show, there will be times that Ryan and Gina Marie need to step it up and cover their aspects. So I am poorly prepared. Laura is not poorly prepared. She gave me a lovely bio that I'd like to read to you. Laura is an LPA, licensed practicing attorney. She went to the University of Notre Dame and graduated from the Notre Dame Law School. She has worked as a judicial law clerk in the city and village administration, county level prosecution, and since 2017, she's been in private practice, including real estate, probate, estate planning, and a statewide Ohio practice in land preservation and related tax law. Laura has lived in Yellow Springs since 2014. And then the rest I'm going to improvise on because I've gotten to know these folks pretty well over the last few years. Ryan Beach has been the financial advisor here at the Yellow Springs Senior Center since before I came on board in 21. And he has been a go-to person for everything from talking to the staff about how they're going to plan for their retirement, but also I know he's got a lot of key connections within our community, helping them talk about how to protect themselves financially. Ryan is a husband and a dad and has a dog. And is a local Edward Jones representative. Yeah. And Gina Marie, we actually raised our kids on the basketball team together, but Gina Marie's mother of two. She's the executive director of the Yellow Springs Community Foundation and actually came out of the fashion industry. So has a wild, wonderful business background. So thank you all for being here. And I'm going to let Laura, I guess, take over for this. Oh, wait, we're going to. Do you mind?
Oh, yeah. So since it's a small group, we would like to hear, if you would mind introducing yourselves. And then if you have one thing or two things you want to say that are of interest, so to make sure we hear it and that we probably will touch on it anyway. You certainly don't have to, just be here for general education. Would you like to start?
I'm Frank, I'm retired and I don't have any questions.
In the back.
Crystal Walker. I'm retired. I own the toy store in town. I was a businesswoman on the national level. And I've been running this all my life.
Sorry. In the back, please. Sorry, with the hat. No, Sasha, can you say it again?
Sasha, retired.
I'm Barbara. I retired from 2 jobs. And I've been in Yellow Springs since 1977.
Before Ryan was.
Just gonna say the same thing.
Jonathan Platt, Executive Director of Story Chain. Very happy to be here.
David Rubino, I've been wanting to come to these Thursday things for years and I never seem to remember, but I'm here finally.
Hey, I'm Lon Height and I am a retired jack of all trades. I've had several careers. And I am a client of Ryan Beaches.
I'm Jerry Sutton. I'm president of the Yellow Springs Senior Center Board. And Carolyn and I have a mission. And it's try to deliver that thing. And so we're interested in how to raise money and listening to entice people to give to our cause.
Okay, so I have titled this presentation, Making Gifts. I could have also entitled it Estate Planning or Lifetime Giving, but I wanted to cover a couple of things. But before I do, this is a disclaimer, me and certainly Ryan, we have to present. This is for your general education. It's not individual, legal, or financial advice. So take it in that spirit. We can answer general questions, nothing about your specific situation. Of course, you could say, I have a friend, and then we probably, okay. Okay, there's disclaimer. Thoughts. Just going to start with a few quotes there on giving. Winston Churchill, we may be giving by what we get. We make a life by what we give. You've heard that before. And there's a few other quotes. Carolyn, I need to ask you a question. Can the audience see the presentation?
No, when we end it, we will make it.
Okay. So for the audience, there's some other quotes up there. They'll be on your handout. I'm not going to read through all those. So one way to think about gifts is gifts at death time, which is what a lot of people think of as estate planning. But estate planning also involves lifetime gifts. And I'm a big fan of people making, certainly in our cohort, and I'm going to sign up for Medicare in October. So making lifetime gifts, if it's appropriate for you to do so, given your situation. Few cartoons. This person doesn't need a will. She spent it all, so she wants me, the lawyer, to draft a will. Okay. Well, first let me say something about probate. Like everybody wants to avoid probate. Well, what is probate? Above all, it is a title clearing function. Above all, it is a title clearing function. So keep that in mind. Sort of the last thing we want to have happen as a lawyer, I'm hoping when someone passes, the family comes to me and says, well, we need to go to probate. And I get to say, no, you don't. You don't have any probate assets. So we'll talk about that. Giving gifts at death and avoiding probate. So you have to make it clear who gets the thing, if it's money, a thing, a car, a house, real property, whatever it is. It has to be clear usually from a piece of paper, who gets it next. And it has to be binding. So good examples of this that you all know, probably don't raise your hands, but a lot of people have life insurance. This is a great example that almost everybody understands. Life insurance is an agreement between you and the life insurance company. You signed a contract. You might remember that. You get a policy. As long as you pay the money, upon your death, if you have named beneficiaries on that policy and it all equals 100% of that policy amount, that death benefit, then that is a probate asset or non-probate asset? Non-probate asset. However, if I have a life insurance policy and I name Jerry, my beneficiary, for 98%, guess what? There's 2% that you can't look at that contract and figure out who gets it next. If we can't figure out by looking at a binding piece of paper who gets it next, we got to go to the judge. So the judge can tell us who gets it next. Okay. So beneficiary designations. Brian, do you want to say something about that? Where else do beneficiary designations appear?
Yeah. Can everybody hear me? Do I need to use the mic?
Don't
So-
use it anyway.
Really? Correct. It's new territory. Probably should test this on Friday. Yeah, so I mean, one of the things that we do at the practice, and what I encourage everybody to do, is review your beneficiaries on a regular basis. So the big ones for us are transfer on deaths on brokerage accounts and naming beneficiaries on IRAs. What's great about that is you can name people, you can name places, you can name a combination of each. Just making sure that someone is named is really the most important thing. Review them every once and again. There've been times in my career where I've looked at, to use the life insurance illustrations, looked at old life policies and somebody had their ex-spouse still listed as the beneficiary. Somebody had a deceased spouse listed as the beneficiary. All of those are things that not necessarily they wouldn't necessarily be probatable, the dead one would, but sometimes you don't want to leave your money to your ex, especially if it was a messy divorce. So, to Laura's point, review it on a regular basis.
Yes, you want to revisit, especially if big life events like somebody passing, a divorce, things like that. Okay. So you have beneficiary designation forms. They also have different names, like the banks, a lot of, you can do PODs, pay on death, on bank accounts, for example, checking and savings. Transfer on death is synonymous. The Ohio Bureau of Motor Vehicles uses TOD. You can have a TOD, transfer on death affidavit, on a vehicle that's been paid off, so that on the face of the title, it will show you have to take it in with your transfer on death affidavit and get your title reissued with the name of the person or the charity or organization on it. I do a lot of TOD, help people with TODs on the BMV 3811 is the form, on vehicles to like Senior Center, WISO, Glenn, So that just appears on the face of the title. Again, we can look at an official piece of paper and tell who gets that vehicle next. That includes RVs, motorcycles, boats, trailers over 1,000 pounds. These are all things that have a title. What doesn't have a title? Well, one thing that surprised me in my practice is farm equipment doesn't have a title. So you got some combines that are worth a lot of money and tractors that don't have a title. So anyway, just for you farmers out there, yes.
First of all, I've got PODs and TODs on my bank accounts. I've never had to give an affidavit.
No, yeah, so that's by contract. So when you
The motor vehicle department requires one?
they use a transfer on death affidavit form BMV 3811, you can get it off the internet, but you have to fill it out, it's gotta be notarized, take it in with, you have to have title in hand, take it in, get it reissued with the TOD on the face of the title. Some people forget that last step. And that's why it's good to have somebody helping you, make sure you do it. Lawyers, but if you follow instructions really well, yeah, some people think just because they pulled the BMV 3811 off the internet and they got it notarized that they're done. They're not done. You have to take it in with your title, get it reissued. Okay, so regarding, I might touch on this. So when you're giving to an organization, you have to make sure you know the name of the organization, the legal name of the organization. It's always good to have the EIN on the BMV 3811. And so the form is set up to give vehicles to persons. So it says SSN, but that's obviously where you put the EIN if it's going to an organization. But that EIN, that entity identification number, is what helps pinpoint which organization you're intending to give to. I'm sure many of you know that there are several national and international charities. And a lot of times they operate at a local level, but they want you to give to the national. Okay. So some people no, I want to benefit my local Humane Society. But if you went to the Humane Society's website, you would get the national EIN and the national name and you know what I mean? So I do a lot of research. I try to help people pinpoint, well, I want to give money, again, to animal organizations. There's just a plethora of them. So you want to make sure if you're giving to that, you're giving the right one. The Senior Center here has your own EIN, is that correct? Okay. So a lot of our, some things are surprising, like A lot of people give to WISA, well, that's not their legal name.
Miami Valley
Public media, that's right, okay. All right. Now, you can't avoid paying, well, you can't, so that's a whole nother topic, debt and taxes and all that, that's not. Okay. So then, gosh, you've talked to Ryan, you've talked to me, you've got your BMV 3811, you've done all this stuff. Like, well, why do I need a will? Well, the will is a broom. Because life happens. We forget stuff, somebody passed, and before we could get back to Ryan or get back to our financial whoever or change that beneficiary designation. It's something. Okay. So what the will is, you have to think of it as a broom. It sweeps up whatever we forgot or life happens. An example I like to use, for people who occasionally play the lottery, let's say, you go out, you buy the ticket, it hits big, and you have a heart attack because you're just so excited. Well, guess what? Is that lottery ticket, it is a probate asset. Why? Because on the face of that ticket, we do not know who gets it next. Is it your wife, your husband, your child, all your children? Who gets it? So that's where the will comes. That would be a probate asset, and then we'd have to then lawyers like to say, if you don't have a will, if you have not made a will, the state of Ohio has made one for you. It's called the intestate statute of the state of Ohio. And generally how it works, if you haven't written a will, first they'll look, besides a surviving spouse, of course, and we can go into that topic, but they'll look if you don't have a surviving spouse, it'll go to your children. If you don't have any children, if you have a surviving parent, it goes up to the parents, so it goes down, up, and then sideways to your siblings, and then on to cousins and so forth. So there's an order to it that the judge can look at. Okay. So what is a basic estate plan that everyone needs is 4 documents plus probate avoidance advice. So you have your advance directives, your Ohio healthcare power of attorney, naming somebody who can make healthcare decisions for you in the event you make your own. Plus, you always want to have a backup or a contingent person if that other person is either unavailable, unreachable, or can't perform the duty. You have most people, not everyone, but most people want a living will that says what you want to have happen if you are terminally ill. Your doctor has certified that you are terminally ill on your medical record. Terminally ill means to a reasonable degree of medical certainty, you have less than 6 months to live. So living will has nothing to do with pre-terminal healthcare decisions. That's where the healthcare power of attorney comes in. And it only deals with artificially supplied nutrition, hydration, respiration. Okay. Durable power of attorney for financial management in the event you're unable to manage your own affairs, either temporarily or long-term, due to whatever circumstance. So that person needs to be good with money. So I ask people and responsible, and they're paying their bills on time. The kid who maybe isn't paying their bills on time or has a lot of debt or has other issues in their life that they're not managing their own lives very well, that might not be the person to manage your life. So, and you can look to dear friends who are good. So anyway, think about that. But a durable power of attorney is a lot of responsibilities. So not everybody has somebody who can do that for them. And so that gets into a bigger conversation.
Hey, Laura.
Yes,
Can I add one thing
absolutely.
there?
No, go ahead.
So first off, the will is a broom, like we rehearsed this a couple weeks ago. That is the best description of a will that I've heard. I've used that like 6 times since I've been jumping. So kudos to you for that. My side of the desk, basic recommendation, if you've got a power of attorney that is going to manage your finances, God forbid if something happens to you, do them a favor and introduce them to the person that you're working with. Introduce them to your lawyer, introduce them to the people that are gonna be a part of your situation, even if you're not capable of it. You know, there were an accident and you were to become incapacitated in some way, shape, or form. Do them a favor, don't make them play off their back foot, introduce them to your financial planner, introduce them to just the important institutions in your life. It doesn't have to be a big how to do, but you know, I think you'd probably second that, just it makes it easier for everybody. So there's my 2 cents. Everything here is, couldn't recommend it enough.
Yeah, and I'd say also, you know, you'd want to take your power of attorney form to your bank and to your broker. So they can get it of record, and then their legal department looks at it, and then sometimes their legal department. They want some changes because of their own policies. This is sort of an internal debate in the probate lawyer world. So there is an Ohio statutory power of attorney, and our attitude is it's the Ohio statutory power of attorney, so why don't you like it? Yeah, go ahead.
May want to mention that upon your death, that power of attorney
Oh,
is worthless.
yeah, so upon death, it goes poof. Because it only survives as long as you, the principal, are alive. Okay, and that kind of estate plan plus the probate avoidance advice, which is basically, let's make sure your beneficiary designations are up to date and how we want to pass this or that. And it can include lifetime giving advice. And again, I'm like, well, some gifts really lend themselves to being given during life, like once you're really ready to part with it. We can, you know, we can talk about that, what those might be, but for example, like really like smaller gifts, like I would say under $25,000, for example, like is it worth, other than the beneficiary designations, but let's say you just want to give that a big gift to an organization or to somebody who maybe isn't your children, but a friend you had in college, you really want to have a nice vacation. Instead of making them go through any kind of probate or fumbling with your beneficiary designations, because we don't really want to touch those if they're good. Let's just give that one $5,000, $10,000 gift. Go ahead and give it during life if you're right, but that takes a lot of talking and anyway.
Making sure you're not trying to get on Medicaid by giving your money away.
Well, yeah, I was gonna stay away from Medicaid. I mean, so, you know, yeah, so, you know, if you're doing it with fraudulent intent, you're like about to go on, although there's Medicaid eligibility planning, which is perfectly fine and involves giving. But that is a much, much bigger topic. And as a matter of fact, it's so specialized that I will do it and implement those plans, but I work with specialist attorneys to do the plan because those rules change all the time and it's like brain surgery and I'm down here in general practice world. So, okay.
Can I ask?
Yeah, sure.
I want to back up to the
Okay.
will of the room.
Okay.
You mentioned having a lotto ticket and not knowing who it goes to next. But if I already have a will in place and then I buy a lotto ticket and I die, that's not covered in the will.
Yeah, you know it is.
Oh, so
The residuary clause. And that the big kahuna in most wills is not the specific gifts, like I give my grandmother's engagement ring to my firstborn daughter, you know. It's not the specific gifts, usually it's the residuary clause, which is I give all the rest, residue and remainder of my estate equally to my 3 children, share and share alike. Whatever the language is. So therefore then we would liquidate, so if you go through probate, one of the first activities you do is you have to inventory everything that is a probate asset. So the lottery ticket would go onto the inventory to show the judge. You have to file it with the court, show the judge what the inventory is. Then comes the payment of the debts, whatever's claims, all that stuff gets taken care of. And after all that's done, then whatever's left, which is the residuary, goes whatever the will says. So, okay. Anybody, I can pause for more questions.
I have one question.
Yeah.
What's wrong with going through probate? What are we afraid of?
We aren't afraid of anything. It's just, and sometimes it's good, especially I think if there, sometimes there are situations in families where it's good to have the judge kind of sitting there. Some people need a judge. And I mean, it's, if people are disagreeing about something, I'm like, well, let's have a status conference with the judge. And suddenly they all learn to agree with each other. So, yeah, but, okay, number one, there's like, in Ohio, you have the creditor's claims period, which is 6 months. So they have 6 months. You really, in terms of settling people's affairs, that's really the safest to do after 6 months because all creditor claims are cut off if they're not made brought properly within 6 months. So there's that waiting period,
You can't distribute until after that.
Yeah, no, it's not like somebody dies, everybody cries, we do it, we kind of gather it. Laura reads the will like in the movies and then we distribute. That's not how it works. That's dramatic, but it's not how it works.
Well, I've been through that.
Yeah.
Had some difficulties, but none of it had to do with probate itself.
But probate's very orderly and sometimes you need that to handle an estate.
Don't you need a lawyer to go in?
Oh, yeah, well, you can do your own probate, but no one, including the judge, would recommend it.
Yeah,
So it's very, very,
costly to hire a lawyer and it takes a lot of time.
so every court in Ohio has a fee schedule guidelines that the lawyer has to abide by and the fiduciary. By the way, how many of you here have survived being a fiduciary? So is it a lot of work or a little work?
Depends on how conscientious you
It's a lot of work.
are. CD, it's a lot of work.
It's a lot of work. So you get a fee per the guideline. So people, they do work, they get a fee, and that's per the board guide. Now, if it's a family member, a lot of times they'll waive the fee because, and it is a fee, so you'll get a 1099 from the estate. That's one of the things. So the lawyer makes sure the taxes get paid and the 1099s get issued and all that stuff. If it's a big estate, I'll have a CPA working with the estate to make sure we account for everything. You have to account to the penny. Lawyers have software. It's different than regular accounting. I have a probate accounting software I use to do that. Yeah.
What is the percentage in Greene County?
Generally, think about 3%.
Okay.
Yeah, but not every estate. So they're basically, you've got 3 kinds of administration. 4 if you're looking at surviving stuff. So you have summary, that's under $5,000 where you have a funeral bill. That goes one direction. Then you have release, air quotes, release from administration, which in many ways lawyers think is just as much work as the full administration. You have it below 35,000 and below for non-spouse people, and then for surviving spouses, 100,000 and below. You can do a release, but that's kind of a misnomer. And then you have full estate administration. And that's more work, yeah.
Earlier on, you mentioned what the CRA does when they're working estate and do an inventory. I would recommend the individual does the inventory and has a list of assets. Every year, state of Ohio publishes a list of abandoned accounts. People are forgotten and work at some place, have a retirement account, and forgot about it. if somebody doesn't step up and claim that, guess what happens to the asset? It goes.
Eventually it goes to the state and pays for.
It builds the Cleveland Browns Stadium. That's exactly right.
Yeah, so in the estate planning process, the very first thing I said, before I'll talk to somebody, I'll say, here's your homework. I don't care if you use a spreadsheet, a notebook, college rule, notebook paper, make a list of all your assets. I don't have to know the exact amounts, but give me a list and approximate balances. And then make a list of any major debts, like mortgage against a house is an obvious one, you know, any big debts. And any other things I should know about. Maybe there's a judgment out there or something, you know. Anyway, so then we figure out how to deal with all that, but and yes, it should be updated every year, you know, and so I give people an estate planning folder, and it would be great every year, if, you know, you make a new list, and then if anything is significantly different, then call the lawyer or call Ryan and see if you need to do anything different.
I'm not sure you answered Dave's question.
Okay, which is what?
What are the negatives about going to probate?
The negatives of going to probate?
Yeah.
It takes time. I was trying to explain that it takes time, and people are usually in a hurry to get their money. Or whatever it is.
You can't do it yourself, so you're gonna have to pay somebody.
You know, you will pay, obviously, there are some fees that come out of it. But often, again, if the family member is the fiduciary, you know, parents usually name one of their children. Well, that child is the administrator or the executor for the estate, but they generally don't take a fee because they're going to get a 1099 pay tax on it, and they're getting a third of the estate. Generally, they don't, but they're entitled to it. And then you have to pay, you know, the lawyer, maybe a CPA if it's a big estate. But you often have to pay a CPA anyway, because you got to do the final tax return for somebody. So it takes time. Ideally, it gets done in 6 months, but that's pretty rare. It's usually 6 months to a year. I think that's the biggest thing about it. People are anxious. I guess you're kind of, well, excuse me, Luan's looking at me like, no, I'm not leaving. No, is there something you're satisfied with? I'm just asking, maybe you're thinking of something I'm not touching on. Okay.
So you said you're estimating 3%. Now, I assume that this 3% of the probatable assets, not the entire estate, the things that, you know, are.
Yeah, there's,
from death and,
there's, that's
So
basically, that's,
minimizing
most
probate
estates are that.
is good and maybe not necessarily eliminating it entirely. Although I can see the advantages of eliminating it entirely, it may not be possible for various reasons.
It's, you know, it's a lot of work, and there are a lot of legal things that you need to do, whether you have a lawyer help you or not, they still have to be done. And, even like with the, I'm going to get the trust next one. I just touched on it. I'm not going to talk a whole lot about them, but people here. So you have this basic estate plan. That's what most people seem to want because it's lower cost, and it serves most people's needs. And honestly, if they've done a good job at downsizing and giving away during life, and then they've got beneficiary designations, and they took care of the car, and literally, I love it when people, the survivor comes in, or survivors, and I say, look, you're done. We don't have to probate. There's nothing that is a probate asset, you know. So that's cool. But you know, it takes, people need to stay on it every year, kind of review what you've got, and those beneficiary designations. Trusts are more expensive. Trusts are kind of like almost pre-probating, like, they can totally avoid probate. If you have named everything into the trust, you still need a will. It's called a pour over will because it says the residuary goes into the trust. Just in case, again, that lottery ticket, now you can on Schedule A of the trust, you can list the lottery ticket by number. If you're that with it, and you can do that. There are all kinds of trusts for all kinds of reasons. The people who need them most are people with loved ones who have special needs, I think. You definitely need to think about it. There are specialty trusts, Medicaid eligibility trusts that are irrevocable. Once you sign them, they cannot be undone. They can be decanted, but they can't be revoked. But for most people with, I would, again, this is a moving target, but, but certainly under 500,000 plus a house, you can probably pass everything without a trust unless you have a special reason to have it. What is a trust? So it's a relationship. One thing you learn in law school that you're like, really? Is a trust can be oral. And the judge can then say, well, there was a trust here, so-and-so gave you this money to take care of that dog. And you went and blew it on gambling but judge, there's no written, well, we have other evidence that this is the trust you set up.
By a witness or something.
Oh, yeah, you have, texts or, other evidence. They set up an account with the dog's name on it. By the way, I love pet planning. Here in Dayton, we have one of the state's leading pet planners. Laura Martin, I think is her name, but she's over there in Dayton. And if you want to get into pet planning, she can go to the nth degree with you, including racehorses and show dogs and, different pets have different animals have different needs, and she can set those up. So, okay. So if you have some reason, then you can go that way, but they're more expensive. It's almost like when I say like so you've got to really think through things. You've got to title things correctly in the name of the trust. You yourself, most trusts are grantor trusts. That means you're the person who is both the settlor and the beneficiary during life. So husbands and wives set these up. So those grantor trusts just use the SSN of the people who set it up. They don't have a separate EIN like an irrevocable trust does. I could go on, but let me use another picture. A trust is a bull. The will was the groom, a trust is a bull. And the key thing about the bull is you can create the trust. It's a document which takes a bit of time for the lawyer to draft, a lot of talking through stuff. You set it up, but if you don't put anything in the bull, there's no assets in the trust. So what do I mean by that? Example, most people, their biggest asset that isn't an IRA or 401k is their house. Well, how do we get the house into the bull? You have to retitle the house from your individual names to your names as trustee. So you quit claim from Laura Curlis individual to Laura Curlis trustee of the Laura Curlis family trust. So you have to completely change the title, which is a recording in the recorder's office. If you don't change the title, the house isn't in the bowl. And this is the biggest problem with trusts. It's I call it the care and feeding of trust. And then you have to take off your individual hat, and you have to put on your trustee hat. So when you're doing anything financially for the trust, you sign, trustee. Okay, so you're writing your check to pay the taxes on the house. You have a trust, so you have a trust checking account. Yeah, right, that's what I mean. It takes training. Yeah, I know, right? It takes training to run the trust. So then you would you pay your taxes with a trustee check, signed by Laura Curl's trustee of the Laura Curl's Family Trust, and that's the account I pay my taxes out of. Now, will the treasurer take a check that's just not a trustee check? Oh, yeah, but okay, that's how you're supposed to do it. Okay. Now, not all assets, though, should go in the bowl. So Ryan may want to say something about that.
Your IRAs and other retirement accounts, you can name a trust as the beneficiary. You cannot put the trust as the owner. So the I in IRA stands for individual. That means you are the only person that can ever own that asset while you are alive, unless you take the money out of the IRA. So I'll have clients come in on occasion, they've just gotten a trust done and they're really excited about it. And they sit down at the office and they go, great, now let's put our IRAs in the trust. And I have to walk them through the implications of doing so. And they go, oh, well, what do we do then? And it's a simple workaround. You just name the trust as the beneficiary of the IRA. So that upon your passing, all the money moves into the trust and then we follow whatever instructions, excuse me. In this case, Laura put on paper.
Is there any advantage to that? I mean,
That's a Laura question.
well, I'm forgetting the details about inheritable IRAs.
Yeah.
You have to, if it goes into the trust, then you have to liquidate it essentially immediately.
Not-
Or is that not?
Not necessarily.
Okay.
Not necessarily. So again, not a lawyer, full disclaimer here. I often find that if the final destination is a person, so like, my wife and I, we have a dog. If we had a trust, it's often more efficient to just name my daughter as the beneficiary of the IRA.
Yeah.
Rather than name the trust, which then would eventually get it to my daughter at the end. Now,
No, that was my understanding.
Yeah.
But I can't remember.
or anything you want to add to that?
Yeah, so with disabled children, surviving spouses, there's an inherited IRA, you can stretch out the amount of time that they can keep letting it grow tax-free. And so you don't want to necessarily have it go to the trust.
Right.
Yeah, that's what.
It's a pre-tax IRA, for sure.
So there's some
Even the
nuance.
wrong, and then, is the person a minor? When are they gonna need the money? Who's gonna help them make these decisions? I mean, there's a lot of factors that go into whether it should be paid to the trust or just go to the individuals. If you have competent children, or charities, the charities don't pay tax, right? They don't pay tax. So that's a good place to make a charitable gift from a pre-tax IRA, for example. But you want to take advantage of that stretch. It used to be unlimited stretch, and then they changed it to a 10-year stretch for children, unless it's disabled child. It's a lifetime stretch for surviving spouses.
Yeah.
So. Okay, lifetime giving. Yes. Just because you made an estate plan or a trust doesn't mean you can't make gifts. Now, everybody's situation is different. So you can do gifts through the will, through the trust, on a schedule or on a list. But you can also still make gifts during life. And with IRAs, the pre-tax IRAs, once you're 70 and a half, you can give up, it's 100,000, Ryan, you give up to 100,000. Total or a year?
For the qualified charitable distribution?
Yeah.
111,000 per
There we
person
go.
per year.
There we go.
Yeah.
Per
we'll
year.
Touch about it in a second.
Danger.
We'll get there.
What?
No danger of hitting that.
Get the lottery first.
So there are tax advantage ways that should be considered, So charitable gifts can be made in the same manner as any other gift. As I've said, it's a beneficiary, TOB Wills Trust. And I talked about the EIN. Now, one thing with charitable gifts, sometimes people want to get into this topic. is, the gift is generally going to be considered unrestricted, meaning the charity can use it for what they need it for, unless you restrict it. Now, some people, especially with larger gifts, they have reasons for making the gift. Sometimes it's a naming gift, or they're giving it for a specific room in a bigger building, or, you know, it's always good if it's a bigger gift. Again, that's a judgment call, but it's good to have a donation agreement, even if it's a letter agreement or one pager. I don't know, Gina, or you may want, I've had the IRS ask for a donation agreement one time. And they decided they were going to do a desktop audit of somebody, and they needed to see the donation agreement. Fortunately, we had a donation agreement. Sent it to them, never heard from them again. They just want to see that one piece of paper. Yeah.
But one concern I would have is the difference between a gift and a deal. Can't put stipulations in the gift such that if, you know, you're getting a benefit from it.
Well, so another very complex topic Jerry brings up is donative intent. So if you're intending to take a tax deduction, you have to have donative intent. And that's a facts and circumstances driven thing. And generally there's letter rulings and case law about giving naming gifts. The charity can agree that they're going to name a building after you. That doesn't mean you don't have donative intent. That may be of value to you and you want your family's name on that building. That doesn't negate the fact that it's still eligible for a charitable deduction. It's very facts and circumstances driven, but you're right. In my business with farmland and dealing with conservation easements, for example, and donations of land, the big thing is, did you get any kind of consideration from governments with developing other land, like land next to it? Like, did you get your development approved faster or more lots because you donated this land over here? See, that's more of a quid pro quo kind of thing that they're looking for. But yeah, some of these things that charities typically do with recognition and then the agreement too is just, you know, you can have donative intent and still be focused on one aspect of a charity's work. Like you're a car dealer, you know, like pick your favorite car dealer. We're going to give you 10 cars, but you need to use them in your transportation part of your charitable work. You can't like raffle them away or something, you know, so that would be what I mean by this donative agreement, that what is the purpose of the gift and what's going to be useful.
I guess I'm receiving it from the receivers. I've been on a couple of foundations and we always have due diligence on the acceptance of the gift. In other words, somebody comes in December 25th, wants to give you their former gas station and want it done by the end of the year. You got a problem. Because it's probably a toxic zone and they're trying to give it to you. You need to have due diligence.
Yeah. Yeah, so that's, you bring up a very complex one. But maybe the charity can conditionally accept the gift subject to the fact that it's not a toxic waste dump and blah, 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 blah. And, you know, and they still get their donation. Again, that for that kind of thing, you definitely should have a lawyer and look at some case law, some rulings, and see how to structure it to make it work.
Gina Marie.
Because I was just gonna say that donor intent is one of the things that the foundation we work with, ensuring that the donor, what they wanted to do with the money, that we can actually ensure that we can do as they choose. So they might ask us or provide this gas station, and we do have a requirement to go through due diligence, or they may ask us to ensure that charity they want to receive the money uses it to paint the outside of their building blue. Well, we can say it can be for building maintenance, we might be able to do that, but we're not going to be able to ensure that the donor's wishes for it to be painted blue can be carried out with those funds, so we wouldn't be able to accept it in that way. So donor intent is something that we work with regularly, and we have a process for which we evaluate our ability to meet the expectation.
Yeah, so conversation is really the key. Start early with charitable, bigger charitable gifts, or if you really want to do, achieve a certain result for the charity, that's important to have that conversation with the charity, if maybe the lawyer comes in. Okay, so making gifts, you can use any of those things we talked about that you can use with people, you can use with organizations. Real property, I do a lot of transfer on death affidavits with real property, that's statutory in Ohio. If you record them in the recorder's office, they don't affect your mortgage, so you can have a mortgage and do a TOD, because the TOD, you might think of it as springing. It doesn't mean anything really until death. So it's a nullity in terms of you can still buy us, sell the property. The mortgage company doesn't get upset that it's not a transfer of an interest because it's nothing till death. And they know that if you pass, it's going to get transferred anyway. So TOD affidavits are, now they are the downside, they are public. Back to the trust, the one type of family or person who probably should have a trust is if you are super private. If you are a super private person. I've worked for government, and when you work for government, the saying goes, you live in a glass house. I mean, everybody knows what you do, It's all, so, many of these things are public record anyway, but if you want to transfer a property on death and you don't want it on the public, who gets it on the public record, then you would have to put it into a trust. Yes.
The transfer of gift for real property. Just as if, for instance, could somebody do that for their real property and then have the designee for the transfer be a foundation with instructions on what that foundation could do with it?
So the TOD would just say to the foundation or the charity. That's where that, and Gina is going to talk about. It would not be public record, the donation.
I don't care about public record, that's not important, it's just what can be done to get it done the way I want it done.
So from the foundation's perspective, we do accept gifts such as a house, a transfer of death, and then with that, coupled with it, we would have an agreement that is waiting until that gift is received, and then we would follow the instructions that we've agreed to in writing that are a part of that fund agreement.
So this is good. I need to talk to you. So
Yeah. You wouldn't put up that of record, that wouldn't go, and actually, I'm not sure the recorder would accept it because it wouldn't be in the statute, on that kind of document.
I have a question.
Oh, I didn't say one. Yep.
So, if you put in your will or trust, a gift on death, a gift to a non-family member or an organization, what happens to that gift, financial gift? Or maybe not, maybe it's a property, I don't know. But what happens if that person predeceases you or the organization goes belly up before it's.
Well, okay, let's back up. We're gonna try to avoid probate. So if at all possible, again, you have to tell me what kind of asset it is, and can we pass it through one of these probate avoidance devices? beneficiary designation, TOD, POD, BMV 3011. Can we get it some other way? But then again, the will is the broom. So it's in the, you know, if that gift fails, that person predeceases, then we have to look to the will. Then it would go into probate, and then the residuary clause would say, you know, if the, you know, I intend to give the car to so-and-so, but however, if she predeceases, then I want the car to go to X, Y, and Z.
Contingent beneficiary.
Oh, yeah, so that's where, again, it's the will is sweeping up. You know, life happened, your friend died before you. You know, so. You can't do, I've never done it and I don't think you can do it. You can't contingent 3811. It's not on the form. That's the next level thing. Nobody's asked me to do that. I've seen it. I'm certainly not on the form. So, okay. QCD, the qualified charitable distribution. Me personally, I can't wait till I'm 70 and a half to make some of these charitable gifts from pre-tax assets.
They're wonderful.
Right? Okay, you want to say something? Say more. Some people are excited like me to do it.
Well, for a lot of our folks, including somebody that's going to the garden dinner party, part of that is fits her qualified charitable distribution. So she sent a check from her IRA to cover part of her garden dinner party tickets for her and her friends. There are all kinds of ways like that that you can send money to us and avoid paying taxes on that.
I'm gonna ask Ronnie to talk about RMDs and these.
Yeah.
Went backwards.
Now we're going RMD, QCD.
I'm sorry.
And that's good.
You guys are the admins.
Yeah, I'll lump them all into one.
So. Go back in time 10 years, QCDs were never a guarantee. There was a period in time where every year there was a question, can you make a qualified charitable distribution or can you not? It has now been codified as law. They're here to stay. So for planning purposes, you think about your own retirements, qualified charitable distributions are not going anywhere. But they have gotten a little wonky since 2020. So it used to be, if you had a retirement account, you had to start drawing money on it, a pre-tax retirement account, we clarify that. You had to start drawing money against it or taking money out of it in the year that you turned 70 and a half. Qualified charitable distributions also began at 70 and a half. Well, 2020 comes along, the government passes the Secure 1.0 Act, which bumped the required minimum distribution age 70 and a half back to 72. Then we got Secure 2.0, which bumped it back from 72 to 73. And if you were born after 1960, it's 75. So where does that put us? It means that if you've got pre-tax retirement assets, that number one, they must be in an IRA. You cannot do this out of a 401k. You can't do it out of your account at TIAA CREF when you're 403b. Can't do it out of your thrift savings plan. It must come out of an IRA. The minute you turn 70 and a half, you can start to send money to your nonprofits of choice out of your IRA. And that distribution does not count against your income. Everybody following me so far? All right. So if you've got a large IRA and you haven't started drawing against it, you're staring 73 square in the face. Your distributions, your required minimum amounts are going to be big. Giving qualified charitable distributions at 70 and a half is a great way to support the organizations that matter to you, like this foundation and wherever else you give your money. But it's also a great way to work down your future taxable liability if you've got big required minimum distributions on the horizon. So 70 and a half, the day you do it, that's the day your first qualified charitable distribution can be taken out of an IRA.
Much too late for me.
Well, if you are taking required minimum distributions, so you've got money coming out of an IRA every year currently, and you don't need the money. You're living on Social Security, you got a pension, you got a brokerage account. Instead of taking that money and reinvesting it elsewhere, give it straight to an organization and you won't pay taxes on the distribution. It's a great system. Yeah.
aren't there requirements that that organization has to meet in order to receive a qualified charitable
They've
district?
got to be a 501c3. They cannot be a donor advised fund. I wish you could. So you can't give to a donor advised fund out of an IRA, but let me put it this way. I've sent checks to hundreds of organizations that are nonprofits. I've never had one bounce back. Like, it would be pretty rare for it not to work. You want to comment on that?
Well, I would just say that we receive a lot of them from donors and with instruction to provide to a variety of nonprofits, both in Yellow Springs and outside of Yellow Springs. So they send one check in and then give us guidance on how they'd like it distributed. And of course, for us, before we can distribute, we have to review each of the nonprofits to ensure that they're in good standing. So that's one of the responsibilities.
Yeah, that's a great way to do it.
Seniors that are in good standing.
Of course.
Yeah.
Yeah.
This point came up during a conversation earlier, because I was talking about the event tonight, and one of the people I was talking to about it said that, I said that QCD had to be sent directly to the organization, not to you, and then you passed. So I knew that, but then this other person said there was another restriction on who could receive that money. And she couldn't remember what it was, so.
It might have been giving to a donor advised fund. You can't give to we're way in the weeds here, but that would be the only restriction that that I'm super aware of.
Okay.
And then you always want to make sure, that there's a lot of great people doing great charitable work that are not yet a 501c3, and this is a little bit where Gina Marie's work comes in. Sometimes those folks can be supported from a community foundation. Although a lot of foundations have a policy that they only give to other 501c3s. That just guarantees that that organization has gotten a tax exempt determination letter from the IRS. It's their determination letter in the business, and that just is, it's not an absolute guarantee, but if you can pretty much be assured that if you give money to that organization and they have a current determination that hasn't been revoked, that if you claim a tax deduction on your tax return, that it'll be honored by the IRS and won't be audited. So
it's probably a good idea to work through a foundation, unless you know for sure that they're qualified.
but most charities that represent themselves to the public as public charities, they'll have their they'll even have it on their website.
Yeah, well, and if you went to the foundation's website, you could go to the nonprofit directory and all the nonprofits in the community. We have listed if they provided their letter of good standing, their 990, their board of directors, and et cetera. So the certificate's right there.
Your website, and a lot of them don't have.
Well, and we're working with them every day to try and get that all loaded up because they have to share it with us. But either way, when we receive and you ask us to give to the Children's Center, we have to look to make sure that they are in good standing at that time. Even if 2 weeks ago they were, we still have to relook before we can issue.
The donor advised funds, that's a different brokerages have make different policies about setting them up, like how much you have to have. You have a policy where does that have to be a minimum of like 50,000?
10,000.
10,000,
Yep.
okay. So that enables a donor to put the money into a special account at the brokerage and get it out of their hands. And then it can grow tax-free, and the donor is an advisor to it, again, similar to directing your financial advisor at the brokerage to send a QCD check at the end of the year. They'd send it from the donor advisor.
So our donor advised funds fit really nicely in certain situations, would be with investments that aren't in your IRA.
Yeah.
So quick example, let's say somebody in this room bought Apple stock in 1984.
Yeah.
And you held that thing all the way through, and that Apple stock was now worth several $1 million today.
True.
If you sold it, you're sitting on a huge capital gains exposure, your tax rates are gonna go up, IRMA's gonna come knocking at your door, Medicare premiums, the whole nine yards. So a great way to unload that stock would be to transfer the shares, the appreciated shares, to a donor advised fund or an organization like you guys. Once the asset, that Apple stock, is in the hands of that donor advised fund or community foundation, they then can sell those shares at no tax. Add diversification, still allow for investment growth, and then you direct the disbursement of that money either instantaneously or in most cases over an extended period of time. They also function really nicely if you're into what we call charitable stacking, to use a different term.
I don't.
Okay.
Tell me what.
So the standard deduction nowadays is really, really high. So nominal gifts to the senior center, the Red Cross, WISO, you gotta give a lot of money in order to be able to write those off on your taxes. Well, a great way to get a one-time big tax deduction is to stack your contributions. Figure out what you're gonna give for the next 5 or 6 years. Put all that money into a donor advised fund at once, take the big deduction, and then give out of that donor advised fund over a period of time. It's a nice way to do it. It's a great way to add diversification or unload a super highly appreciated stock like Apple that you bought in 1984. And it's more than one way around things, and it's a good way to use the tax code to your advantage.
How do you establish a donor advised fund?
Some brokerage firms offer them, so like Edward Jones, we partner with a company that runs our donor advised fund for us. You can use community foundation. They act they act in a lot of ways like a donor advised fund. Do you agree?
The foundation does have donor advised funds, and then, the assets of the foundation are diversified assets. And we have all invested, and they're pooled together. So I can tell how much is one fund versus another, but the donor advised funds are added to the pool and invested with the foundation's funds. So we manage about 30 donor advised funds at the foundation, which are individual donors, actual funds. And I'll often set them up with us because at the end of their life, they want to transfer funds in there and then have it dispersed, as I mentioned, like they have an idea of how they want it divided up. And so they can keep us updated on a regular basis of how they want that distribution. So.
And then another technique to use, and Brian talked about this as well, is life insurance replacement, where you purchase the life insurance with a death benefit equal to your IRA value. Go ahead.
Yeah, so let's take an example where you've got a loved one that you want to leave money to and an organization that you want to leave money to. This is a strategy that I'll use in my practice from time. Carolyn, we'll use the senior center as the example. Of course, makes sense. So let's say you've got a child and you also want to leave money to the senior center, and you've got a retirement account that is pre-tax. You got a big IRA or a big 401k that you're taking distributions against. Well, if you leave that IRA to your kid has to take all that money out within the first 10 years of inheriting that asset. They're still working, the distributions get added on top of their income. You end up taking a pretty big haircut on what you receive. Just is what it is. So a way around that is to say, all right, I really value what Yellow Springs Senior Citizens does in the community. I'm going to leave my IRA to them. Once Carolyn and the organization receive the IRA, they can take money out, no taxes because they're a nonprofit. In the meantime, if you're healthy, you can then also go buy life insurance that is roughly the same value, or the death benefit is about the same value as the IRA, and you name your kid as the beneficiary of the life insurance. Life insurance proceeds to individuals they're nearly always tax-free. So what you've done then is you've left your IRA to the foundation, they pay no tax. You bought a life insurance policy that's about the same value as the IRA, you leave that to your kid. Both entities win. The only loser here is the IRS. And typically, what you'll do is you'll use your distributions to pay the premiums on that life insurance policy. Now, there's a lot of moving parts, but it can often be a great way to amplify your estate, take care of the people in your life that are meaningful, and also support the organizations that were meaningful while you're living. And again, there's no loser except the IRS.
Okay. And, you know, there are lots of things that are outside the box that we don't have time to talk about. Oil and gas rights, royalties, value collections. Land is a whole topic in and of itself. And then, you know, you can also, if it's things that you have a lot of things that you're ready to part with, artwork, I mean, Carolyn can talk about, and you've probably bid on yourself, some of the charity auctions that they do online. So it's a good way to do that. Swedish death cleaning. That's another thing I'm looking forward to and am doing. Giving stuff away, rehoming, giving to charity to start to reduce all that stuff that accumulated. But if you enjoy your stuff, keep it by all means, but sometimes it's time for it to go.
I mean, we've lived in the same house since 1977. It is amazing how much there is in it.
Yeah.
Stuff you never remember.
Yeah.
That's-
Yeah, exactly.
I don't even know what it is.
And then some people have cool skills that can be, I gotta buy tickets to that Chef Nif.
Yeah.
That's why I put this in to remind myself I need to buy some raffle tickets. Okay, there's next level charitable giving strategies that we're not going to get into, but these tend to be, you gotta have a lot of assets. There are different kinds of trusts, both charitable remainder trusts, that's where the charity gets what's left after your kids or whoever you want to benefit uses it during their lifetime or spouse. And then there's charitable lead trusts. There are charitable gift annuities. Those tend to be done by bigger charities, or a lot of colleges and universities do those. That's where you give them 10,000. And the reason they have to be big is they have to figure out, they have to hire actuaries, or they use a company to help them figure out if this person gives us 10,000, well, what's going to be the annual income? So you give the $10,000 or the 20 or 50 or 100, and then they'll give you a stream of income during life. They'll annuitize it. They'll probably do that through a third party, and then whatever's left goes to the charity that you originally set up the charitable new. Small charities don't do these, but the bigger ones do. So the different remainder trusts or lead trusts or annuity trusts. So there's all different kinds, but that's for much bigger dollars. So. You had this, I knew this group, always in Yellow Springs, you get a lot of questions, which is great, but we also have more time for questions. It's 8:15. I'm happy to stay till 8:30 if people have questions.
Big shout out to Laura. She like put all this together. Yeah.
Yeah.
Thank all of you for coming. This is really.
I just wanted to make one other point on the pre-tax IRAs. If you have a disabled child, they have a lifetime stretch.
Yes.
So it's not just 10 years, 10 years unless they're disabled. So that's a good change in law. Another great change. You have questions about disability law. Again, it's a topic I'm keenly interested in and I know a lot about, but again, I use specialists to help create a plan. But Ohio's been a leader in a number of vehicles for people with disabilities. Another one is a special kind of savings account that it used to be you had to set it up by age 26 and you could have 100,000 in it. And the person who's disabled can get access to it. Now it's age 46, that changed. That's it. That's important. They're called stable accounts or able accounts. And then in Ohio, we have two foundations, the Dayton Disability Foundation and then the Columbus Foundation. It might be one Cleveland too. But they will manage assets for disabled people during their lives and they know all the rules the government benefit rules, so you don't want to disqualify people for their government benefits, mainly Medicaid, but the other benefits. That's a whole very specialized topic, but Ohio is kind of a leader in this, and we have a lot of great resources here. So,
I had an interesting, one of our members came to me, it's been about 4 months ago. She said, I'm doing all of my estate planning. I'm being very careful. I have no children. I have no family in this country. I have no good friends. And who do I trust to be my financial power of attorney? And it was a really interesting puzzle, and we went through several avenues, and I think she even called you at one point, perhaps.
it's one of the toughest questions I get. So if you can't think of someone to name to help you with your finances, if you're unable to do so, then you may have to have a guardian appointed by the court. And the probate judge, him or herself, is the superior guardian of everybody in the jurisdiction. But then they will, what that judge does is they'll call up lawyers mainly and say, would you be willing to be appointed guardian for somebody? It's a lot of, it's a big responsibility, and so a lot of people are reluctant to do it. Lawyers do it because the judge asks. No, it's part of our duty.
And she actually did find a resource that I can find and put, I should have Stephanie have the resource available, but there is an agency you can hire for this.
So there's something called the Association of Daily Money Managers.
Yes.
Now, they're not technically, I mean, I've looked into this and, okay, they're allowed to charge more than I as a lawyer am allowed to charge
okay.
per the judge. And this is one problem actually that, you know, for a lot of lawyers, it's not going to be a moneymaker. And, you know, you're doing it for free or low, very low cost. I can't charge what they charge. So it doesn't make financial sense right now how it is. So people are reluctant to step up to do it as part of their business plan.
Sort of related, but it's off the topic a bit. I've had the same problem because I don't have kids and I don't have, my two sisters are in. All this sort of stuff. My biggest problem is finding somebody who's willing to take on my own care. Right. Because I don't want to impose that on friends. That's a very, very difficult job. And I think I had finally convinced some friends of mine to do it, but I feel bad about it.
What do you mean by that?
And that's, it's somebody who can make my healthcare decisions when I'm not.
Right, so if you're in an accident, you're unconscious and somebody, the surgeon wants to know about amputation, you know, you're out of it, who are they going to talk to? So it's pre-terminal, so you're not terminally ill, and it's who's going to make these decisions, or they've drugged you up to control the pain, you're completely out of your mind because the morphine they've given you. So who's going to help make those decisions that need to be made right now? Usually it's in a context of some urgency.
Yeah.
Then you have the whole category of people who have dementia or Alzheimer's or something like that, and they are not terminal, but yet decisions need to be made for them. So. And the healthcare power, I mean, on the Ohio, use the Ohio statutory, you know, so it's online. Pro Seniors has it online. The Franklin County Probate Court has it. I go there because if there's a fillable PDF, you can fill it out. It's not as self-executing and intuitive as I would like it to be. It was drafted by a committee. All the committee names are at the bottom of the page, and it shows. It is 23 pages long.
Yeah.
So it's actually the advanced directives, the healthcare power and the living, those are the first things I send to people. I send them to them right away. And I say, I want you to read this Cause it's 23 pages long, it's gonna take you a minute. And then you can ask questions, but I also want them to think about who they're going to name as their first agent and then their backup, because those are often the very same people they're gonna name in their will as their executor and their backup executor, and also maybe their residuary beneficiaries.
What if you don't have those people? That is,
It's a.
If you don't, then they'll seek an emergency guardianship if you absolutely need somebody to help you. That's not a good situation to be in. I really try to ask people to
really the harder.
it does.
It's harder becomes if you don't have, children or nieces and nephews or.
Other culture, isn't it the Japanese culture, they have like these almost death circle, like people who have formed friendships. Just, what do they call it? See, I should be more cultured than I am.
But death doula might be.
That's-
With that or not, is that it?
That's more of a, processing your emotional state. It's a lot, it's complicated, it's medical, emotional, spiritual, it's one package that you sort of. But also Stephanie here in our office has that choices packet here, if people just want it without working with FOIA right off. She can.
But yeah, but I gotta tell you, that form, I mean, good luck to you. I mean, it's not, even which boxes to put your initials in isn't into, I spent a lot of time explaining that form to people.
Yeah.
Even if you're a careful reader.
I don't think I'll live long enough to do all these things you say.
But yeah,
myself.
I hear you, and of course, Women Outlive Men as a group. So, you know, and you live longer and then you've lost your husbands or your male friends, and then you start losing your female friends. But try to find friends who are willing to do it that you're willing to do it for them and they're willing to do it for you. That in this society, that's about the best we have. But Adult Protective Services will not do it.
Me, it's gonna be very difficult. So I was caregiving my mother and my husband for almost 20 years. And so I lost myself.
That's why you're coming to lunch now
But
on
this-
Fridays.
Yeah, there's so many reasons why we need the senior center for socialization, for your health, but also for some of these very practical reasons and fun, and we need it.
And great events like this.
Yeah.
Jean Marie, did you have more to cover about the foundation?
Unless there's questions in our buildings there, come stop by and see us, and I'm happy to answer any questions you might have.
Do you know where you can go to find out if you have a lost or forgotten account?
I do.
Right, where is it?
Missingmoney.com. It's legitimate. It's not a scam. All the states put their information into it. That's where I've been through training on this, and that's what the bar says. Use this website because it has the most comprehensive state input information. Yeah, for sure. Go look missingmoney.com and find all those little accounts you forgot about, and but there's some big money, and there are lots of companies that scour missingmoney.com to find big amounts that they want. Then you'll suddenly get a letter, or you've heard these stories probably, that they want a finder's fee of a third to air quotes, help you get it. Now, they cannot, you ultimately have to get a lawyer to get the probate documents to send in to file your claim. I mean, you can't just go find an account. I'll give you an example. When my husband passed, there was like a bank account with $60 in it that was somewhere. And you think I, as the surviving spouse, could just write a letter or file claims. I'm the surviving spouse, just send me the money. No. They want the probate court paperwork showing that account comes to me. Well, guess what? Guess what it costs to do that?
$61.
How about really, for the lawyer's time to do that probate work to get that order is $500. It's still sitting there. It's still sitting there.
It's your own account, not somebody.
And it's not related to a death. Yeah, you should be able to.
It's easier.
Yeah, you should be able to send in your ID and.
It's not totally
easy because
Right.
it depends on how big it is. There was a very small amount that I had donated to a charity, and the charity folded. And that showed up, and it was something like $10. And in order to get it back, it was going to take me hours and hours and hours, and I decided, my time is worth more than that.
That's right.
Every couple of years, somebody informs me that my mother is owed money. And so I've known that for years, but it would cost more to reopen the probate account than the amount I'd be getting.
Yeah.
Of course, I'd have to split it with my siblings.
So stay tuned. The probate bar is aware of this and the Ohio Bar Association, the probate committee. We're trying to get legislative changes to make it easier to get at least small amounts, like under $500, that kind of thing. So we'll see if we get legislation for that.
I have a friend. And a non-family member has appointed her as their executor, and trustee. And she's curious to know as, when that comes up, because this person hasn't got away yet. But when it does, is there a fee that she can charge the trust or the?
Yeah, I mean, trust, if I think the worker's worth their wage. That anyone performing those kind of duties should be paid. Now, some people write trusts saying my trustee isn't going to get paid anything. If I was that trustee, I'd resign. Or I wouldn't accept it. You need to physically on paper accept the trusteeship. Because it's a big responsibility.
So I thought there was a certain amount that the state allowed as that fee.
No, there's no state law on it. It's whatever's reasonable or what the trust said. The trust could say you get paid $10,000 a year to manage this $25,000.
The trust doesn't even designate that any of.
Then the judge, it would be reasonable, a reasonable fee. I mean, reasonable fee is presumed because you're doing work, you're managing somebody's money.
Right.
Which is a lot of work, right, Gina? And, now again, some people try to write fees out, like no land trustee shall not get a fee. The lawyers do try to control corporate fees, corporate trustees, like they only get so much because corporation bank trustees, I'm not bad mouthing them, they have a role to play for sure. But there is, the lawyers do try to control those fees for sure. I would rather in a trust writing a number like 1% of the assets per year as trustee fee or 0.5%. Depends on how big the trust is, of course. And you can write it that way. If the trust corpus grows to over $1 million, the trustee will get this much. If it's under that, this much. You can write it however you want.
I have to excuse myself.
Yeah, sure. Go ahead.
I got to dark.
Yeah, I'm with you.
Another bummer.
You don't like fees. A lot of people don't, but if the peer person's doing work, then they need to be paid. It's a huge, I thought the teachers.
State designated how much the fee is, so that it was reduced every year until the.
How many is trust, the trust is a relationship reduced to writing ideally.
To the 15.
And-
What's the middle?
Yeah.
Or is there my.
Okay.
And maybe your mom.